Hello, my name is Damon Leff. I'm the Director of Legal Services for the South African Pagan Rights Alliance. I identify myself as a pagan witch. I would like to thank the Reverends Hubbard, Lewis, and Hawke for facilitating this Pagan World Conference and for inviting the South African Pagan Rights Alliance to participate. Thank you. I have titled today's presentation, Witchcraft and Religious Rights Advocacy, a legal review of South Africa's 1957 Witchcraft Suppression Act, 2007 to 2025. Please note that I will provide the text of this pre-recorded presentation together with an extensive bibliography on the comment wall of my page on PwC 2025's website. I do welcome discussion on the content, so if you have any questions, please leave them on the comment wall and I will endeavor to answer them as soon as I can. The South African Constitution is founded on three fundamental principles: human dignity, the achievement of equality, and the advancement of human rights and freedoms. In its 1997 judgment, in the case of President of the Republic of South Africa and another, v. Hugo, the Constitutional Court confirmed that all human beings must be accorded equal dignity and respect, regardless of their membership to any particular class or group of persons. Differentiation or discrimination between persons on one or more specific grounds, which infringes on a person's fundamental human dignity, amounts to unfair discrimination. Contemporary occultists and pagans in South Africa remain largely marginalized religious minorities in a largely Christonormative society that avoids, wherever possible, any attempt to engage in constructive religious pluralism. Occultists, Satanists, pagans, and witches are not invited to participate in any interfaith dialogue or initiative on matters of common mutual interest. This aversion to embracing religious pluralism is a product of both an historical, cultural, and religious acculturation of bias, and the consequence of prejudicial media narratives promoted against non-Christian belief systems for many years. It should be noted at the outset that historically only witchcraft has been subjected to legal prohibition in this country, and that there is no existing South African law against the practice of occultism, Satanism, or any other pagan religion. I will therefore briefly explore how cultural, religious, and legal acculturation of bias against witchcraft constitutes unfair discrimination that infringes on the fundamental human dignity of South Africans who identify as witches. South African law has had a long and troubled relationship with witchcraft. Prior to the introduction of colonial Roman Dutch law in South Africa, customary traditional courts had already developed several quasi-legal mechanisms with which to deal with accusations of witchcraft. The practice of witchcraft was often punished by death. Conflicts blamed on witchcraft were mediated where they could. Persons were compensated for false accusations of witchcraft brought against them, and husbands were granted divorces when their wives were pointed out as witches by diviners. It is important to note here that in customary indigenous culture, religion and law, witchcraft is not and was not recognized as a valid belief system or religion to which people might voluntarily ascribe, and consequently anyone suspected or accused of being a witch was and is condemned to suffer the prejudice of judgment and communal punishment. Dutch administration of justice in South Africa refused to entertain charges of witchcraft largely, and the practice of alleged witchcraft was not punished by Dutch magistrates as it was by English. Under English law, accusing someone of witchcraft was treated as a serious offence, and those who killed alleged witches were tried for murder. English statutes banning witch doctors and witchcraft accusations were first passed in territories annexed to the Cape Colony in 1879. The earliest legislation targeting witchcraft beliefs include the Cape of Good Hope Act of 1886, the Black Territories Penal Code of 1895, the Witchcraft Suppression Act of 1895, the Natal Law of 1891, and the Transvaal Ordinance of 1904. With the enactment of the Witchcraft Suppression Act of 1957, which unified existing colonial laws, customary law regarding witchcraft was effectively outlawed, even if still practiced covertly. The Witchcraft Suppression Act not only makes it an offence to accuse someone of witchcraft, but it also makes it an offence to pretend to profess a knowledge of how to practice witchcraft. South African courts, when dealing with charges of professing knowledge of witchcraft, have historically avoided giving any credence to any claim of actually being a witch. The Witchcraft Suppression Act prosecutes pretended witchcraft as fraud and not as a harmful practice or act. Conveniently for both the law and our criminal courts, the South African Suppression Act does not define witchcraft. In practice, this means that the term witchcraft can theoretically be used to define any act that reputes to rely on a supernatural agency, other, of course, than the supernatural agency of a god. I have argued repeatedly that the legal differentiation between magic and religion by our courts would now amount to unfair discrimination by the court on the listed grounds of religion, conscience, and belief in Section 9.3 of our Constitution. No court should assume to judge the validity, influence, or efficacy of any belief in alleged supernatural agency, whether for magic or religion, simply because a belief in any supernatural agency can neither be proven nor disproven through admissible evidence in a court of law. Post-Constitution, and in a 2005 case, Minister of Home Affairs in another v. Fourie and another, the Constitutional Court affirmed that both the religious beliefs held by a majority of South Africans, as well as beliefs held by minority faiths and non-believers, must be equally respected by our courts. In National Coalition for Gay and Lesbian Equality v. Minister of Justice, the court held that religious beliefs, and including the absence of such beliefs, cannot influence what the Constitution dictates with regard to protecting the right to freedom of belief. In Christian Education South Africa and Minister of Education, the court asserted that the right of an individual to act in accordance with his or her beliefs is fundamental to a person's right to human dignity. In the case of S.V. Lawrence Negal Solberg, the Constitutional Court described the essence of the right to freedom of religion as 1. The right to entertain such beliefs as a person chooses, the right to declare beliefs openly and without fear of hindrance or reprisal, and 3. The right to manifest beliefs through worship, practice, teaching, and dissemination. In the dissenting judgment in the case of Lawrence, Judge O'Regan remarked, I quote, "By endorsing a particular faith as a direct and sectarian source of values for legislation binding on the whole nation, the state exceeds the competence granted to it by the Constitution. Even if there is no compulsory requirement to observe or not to observe a particular religious practice, the effect is to divide the nation into insiders who belong and outsiders who are tolerated. This is impermissible in the multi-faith heterodox society contemplated by our Constitution." End quote. As a tolerated outsider, a pagan witch, I have to agree with now retired Justice O'Regan. Considering the significance of these Constitutional Court judgments on the importance of the right to freedom of conscience, religion, and belief, for the right to dignity of a person choosing to hold a belief about occult supernatural agency, the efficacy of magic or witchcraft, we must avoid accepting that any form of expressed prejudicial bias, whether by the state or by an individual, against minority faiths should be excused. Expressed religious and cultural bias against occultists, Satanists, witches, and pagans amounts to unfair discrimination and should never be tolerated. Section 9.2 of the South African Constitution provides that true equality must include, quote, "the full and equal enjoyment of all rights and freedoms," end quote, guaranteed by the Bill of Rights. For South African witches, one final hurdle remains to our achievement of true equality. that is, the repeal of the 1957 Witchcraft Suppression Act. In practice, the Witchcraft Suppression Act legally entrenches automatic bias against witches and witchcraft, especially in disputes regarding employment, divorce, child custody, and it automatically prejudices our right to freedom of expression in the public sphere. After all, the Act says witchcraft can be a crime and witches can be criminals. By prohibiting the practice of witchcraft, the Witchcraft Suppression Act discriminates against witches by denying to us, in practice, our constitutional rights to freedom of conscience, belief, and religion, the right to freedom of expression, equality, human dignity, freedom and security of the person, and our right to freedom of association. It also criminalizes identified practices associated with and practiced by both traditional healers and witches, including the use of sympathetic folk magic, the making of magical charms, enchantments or conjurations, and divination. And it is for this reason, in February 2007, that I requested the South African Law Reform Commission, on behalf of the South African Pagan Rights Alliance, to investigate whether Act 3 was inconsistent with Section 15 of the South African Constitution, which guarantees the right to freedom of conscience, religion, thought, belief, and opinion. Project 135, the review of witchcraft suppression legislation, was eventually approved by the then Minister of Justice and Constitutional Development, Mr. J. Radebe, in September 2010. In March 2011, the South African Commission for the Promotion and Protection of the Rights of Cultural, Religious and Linguistic Communities, the CRL Commission, publicly announced its support for the South African Pagan Rights Alliance's annual 30-day campaign against witch hunts. In November 2011, this alliance submitted a stakeholder submission to the UNOHCHR Universal Periodic Review, in which this alliance detailed ongoing human rights abuses committed by ordinary citizens against innocent citizens accused of witchcraft. In January 2012, the Commission for the Protection and Promotion of the Rights of Cultural, Religious and Linguistic Communities publicly condemned the ongoing violent victimization and the killing of elderly persons labeled as witches, and called on traditional leaders, community councils, and government departments to assist in deepening peace, friendship, tolerance, and respect for human dignity and communal cohesion among all the peoples of South Africa in pursuit of social justice and equality, irrespective of suspicions that would not be able to be proved in a court of law. In January 2016, the Law Reform Commission concluded that the Witchcraft Suppression Act's prohibition against identifying as a witch and professing knowledge of witchcraft was inconsistent with Section 15 and therefore unconstitutional. In September 2017, the United Nations Human Rights Council hosted the very first two-day workshop on witchcraft-related human rights violations in Geneva, Switzerland. The South African Pagan Rights Alliance was invited to attend this event. We submitted a written presentation. The workshop brought together over 100 UN experts, academics and members of civil society from across the world to discuss violence associated with beliefs and practices associated with witchcraft and sorcery. In June 2021, the United Nations Human Rights Council's draft Resolution 47, entitled Elimination of Harmful Practices Related to Accusations of Witchcraft and Ritual Attacks, finally, although indirectly only, acknowledges that witchcraft is not the mischief requiring regulation or prohibition. The draft correctly identifies the true harm requiring remedy, the human rights abuses which flow from accusations of witchcraft. The legal review of the Act has taken 28 years of protracted calls for public comment from individuals, secular and religious organizations, including innumerable delays in processing submissions and finalizing reports, indefinite delays due to staff shortages, and attention to other priority projects. I suspect there was a lot of bias involved as well. In every issue paper released by the Commission, it is recommended that the Witchcraft Suppression Act be repealed. and in every round of public comment, appeals to retain or redraft the current Act have delayed the resolution of the review process. Whilst it is apparent that the Commission does support the repeal of Act 3, it has been requested to consider the drafting of a, quote, prohibition of harmful witchcraft practices bill to replace the Witchcraft Suppression Act. It must be noted here that the Commission is not empowered by the legislature to draft new legislation. In an attempt to appease critics, it exceeds its delegated mandate by doing so. Also, by claiming as it does that there is overwhelming evidence of harmful witchcraft practices requiring regulation and prohibition, the Commission relies only on submitted anecdotal allegations arising from repeated historical, cultural, and religious bias against witchcraft, without providing any actual evidence for the generalized allegations against, as yet, unidentified witches and witchcraft. The current draft bill defines harmful witchcraft practices as invoking a claim to the ability to use non-natural or supernatural means, whether that involves the use of physical elements or not, to threaten or to cause 1. Death or injury or disease or disability to any person, or 2. Destruction or loss or damage or property of any kind, or 3. Severe psychological distress or terror. This definition fails to meet any established legal burden of proof standard. The Commission unwittingly proposes, at the insistence of written submissions, that our court should begin to consider hearing circumstantial allegations of threats of supernatural harm, which can never be proven, committed by practitioners of witchcraft unnamed, by claimants who believe that their own misfortunes are caused by unprovable supernatural means. The Commission is also inviting, according to the bill, essentially fraudulent claims of harm. The bill requires complainants to prove unprovable allegations with evidence or face prosecution themselves. Makers of supernatural claims therefore have an inescapable and impossible burden of proof. The proposed prohibition of harmful witchcraft practices bill amounts to indirect bias against witches and will result in direct prejudice against witches and witchcraft if the Commission recommends that it be adopted by Parliament. African lawmakers may still incline toward believing that witchcraft remains a dangerous and nefarious practice. To address the issue of accusations of witchcraft, which inevitably lead to violent witch hunts, and against which SAPRA has publicly advocated since 2008, the Alliance has drawn the Commission's attention to the United Nations Human Rights Council Draft Resolution 47, Article 6, which reads, and I quote, "States should carefully distinguish between harmful practices amounting to human rights violations related to accusations of witchcraft and ritual attacks, and the lawful and legitimate exercise of different kinds of religion or beliefs, in order to preserve the right to freely manifest a religion or a belief, individually or in community with others, including for persons belonging to religious minorities." In the case S.V. Lawrence, the Constitutional Court Justice Albie Sachs wrote, "One of the functions of the Constitution is precisely to protect the fundamental rights of non-majoritarian groups, who might well be tiny in number and hold beliefs considered bizarre by the ordinary faithful. In constitutional terms, the quality of belief cannot be dependent on the number of its adherents, nor on how widespread or reduced the acceptance of its ideas might be, nor in principle should it matter how the slight an intrusion by the state is. The objective of Section 14, the right to privacy, is to keep the state away from favouring or disfavouring any particular worldview, so that even if politicians need not be neutral on these questions, legislators as legislative drafters must. Whilst the Act has not yet been used to imprison self-identified witches who have publicly declared their religious affiliation, its existence continues to stigmatize actual witches in general as criminals in potentia. It does this by reinforcing negative and harmful stereotypical bias against witchcraft and witches, which ultimately serves to indirectly encourage witch hunts against suspected alleged witches. In practice and as a rule, witch hunts themselves target non-witches, individuals who deny practicing witchcraft and who do not self-identify as witches. In much of Africa, it is ordinary citizens, women, men, and children who bear the burden of prejudice and hostile discrimination born from centuries of bias against witchcraft. Attempting to suppress the widespread belief in the agency of witchcraft as a cause for misfortune, harm, disease, murder, and death won't stop people from continuing to believe that witches are malevolent and must be murdered. Prejudicial beliefs about witchcraft won't change overnight, but changing them must start with education, not with the suppression of access to the truth. It should be noted that since 1957, the existence of the Witchcraft Suppression Act has not prevented accusations of witchcraft against innocent persons. Preventing crime is not the function of legislation. UN Special Rapporteur on Disability, Hissa Al-Thani, once said, "One cannot legislate negative attitudes away, cannot draft laws to eliminate stereotypes, cannot remove from the hearts and minds of people the tendency to discriminate. But we can speak out. We can begin to eliminate negative perceptions and prejudices." It is my fervent hope that my legal advocacy for the recognition of the rights and dignity of South African witches over the last 28 years will eventually result in the final repeal of the Witchcraft Suppression Act and the end of legislative prejudice against pagans and traditional healers. In closing, I am painfully conscious of the very real and existential struggle facing Americans and United citizens right now. Please know that we are with you all in spirit and strength. Thank you.